Hello again, this is attorney Mark Brunner, and thank you so much for joining me today on Talking Texas Law. You know, normally on this channel we have a question and answer format. I'll hear a legal question and I will answer it with a Texas twist about how we do things here in the state of Texas. But today we're going to kind of set that format aside and talk about a case that came from Texas that went all the way up to the United States Supreme Court recently and was heard, and the impact of that case and the importance of it. You know, I had earlier blogged about this case, and you can see a link down here in the Read More section of this video that will link you to my blog where I talk about this topic as well as other topics of legal interest here in Texas. So, like I said, the Supreme Court recently reviewed a case called Buck versus Stevens. This is again a case coming up out of Texas involving a defendant, Dwayne Buck, who was sentenced to death. So he is currently an inmate on Texas death row. The issue was, back during Buck's trial, the issue was whether he should receive a new sentencing hearing, because during the sentencing phase of his trial, the jurors heard testimony from a defense expert, not a state expert, a defense expert, that the defendant was more likely to commit violent crimes and pose what's called a future danger because, among other factors, Dwayne Buck was black. Straight up race-based part of the equation to determine future dangerousness. I mentioned in my earlier post that in my humble opinion, that was an unconscionable, horrible piece of evidence for the jury to have heard, especially from a defense witness who's supposed to be there to essentially try to help Mr. Buck. Someone's race should never be part of the equation when a jury is trying to determine whether to give someone life or death. You know, again, my humble opinion or not, the Supreme Court agreed with that outlook, and they recently ruled in a 6-2 decision that Dwayne Buck should have the sentencing part of his case thrown out. He should have a new sentencing hearing. Chief Justice John Roberts of the United States Supreme Court wrote the majority opinion in this case and likened that race-based testimony from the defense expert as a, quote, toxin that is, again, quote, deadly in small doses. So, again, that race-based testimony wasn't all that the jury heard, and certainly wasn't all that the jury heard from that particular witness, but still, it was bad enough to be likened to just even a small dose of toxin. It's just not good, deserves another shot with a new jury. It's heartening to know that at least in this particular case, justice was done and the Supreme Court were willing to give this case a second look. You know, Mr. Buck's conviction still stands. You know, if he deserves death, then so be it. I mean, he will have to face a new jury, and they will look at this all over again and have a look at what the evidence is about his risk of future dangerousness and his possible risk to society if he's ever let out. And so he will have to face a new jury all over again. But you know, if he deserves death, so be it. But let that jury be one who will make the decision based on the content of his character and not the color of his skin. As always, this video is being offered for informational and educational purposes only. It's not to be considered a legal consultation, and unless you are already a contracted client of mine, I'm not your lawyer. Again, this is attorney Mark Brunner, and thank you so very much for joining me today on Talking Texas Law. I'll see y'all next time.